So far, we have only discussed the subject of public racial discrimination, that is, racial discrimination that is conducted by the government. We're still keeping our focus on public discrimination or governmental discrimination, but now, what about other kinds of discrimination, non-racial kinds of discrimination? What does the Equal Protection Clause have to say about those? That's our subject of this lecture. And if you'll recall, the relevant portion of the 14th Amendment says, "No state shall deny to any person within its jurisdiction the equal protection of the laws." And so our focus here is on that phrase, any person, because the Equal Protection Clause supposedly applies to all persons. However, as we've already mentioned, lots of laws discriminate. And in fact, the way the Supreme Court has interpreted the 14th Amendment is that some groups are protected by the 14th Amendment. Certain groups do receive legal protection from the 14th Amendment, and we call those groups suspect classes. While there are other groups that don't receive any protection from the 14th Amendment. These are known as non-suspect classes, and it is constitutional for the government to discriminate against these classes of individuals without violating the 14th Amendment. So the key question, of course, is what's the difference between a suspect and a non-suspect class? How does a class become suspect so that discrimination, official discrimination against it, is illegal? Well, the simple answer, of course, is the Supreme Court decides. What does the 14th Amendment mean? Whatever the Supreme Court says it means. Well, that's a simple answer. What has the Supreme Court said about the difference between suspect and non-suspect classes? Well, they have tried to lay down some indicators, a definition of what are suspect classes, and I'll highlight 4 of the criteria that they've mentioned. First, they say suspect classes are a discrete and insular minority. This is kind of an ambiguous phrase in and of itself, but it essentially means that it's a group that is somehow set apart from the rest of the community in some identifiable way. A second characteristic of a suspect class is an immutable characteristic. So, for example, many of us have immutable characteristics. Race is an immutable characteristic because it can't be changed. Until the last few decades, of course, gender was immutable and under the law still considered immutable, even though obviously a few people do change their gender, but it's considered an immutable characteristic. Interestingly, of course, this is why the debate over whether homosexuality is learned and whether it's a choice or whether it's something that somebody's born with is important. It's important not simply from a scientific point of view, but it's important from a legal point of view, because if being gay is merely a choice, then homosexuality likely would not be considered a suspect class under the law, because it wouldn't be immutable. If, however, individuals are born gay, then it is an immutable characteristic. So that debate is very significant from a legal standpoint. A suspect class also must suffer a history of discrimination. So one group that might not be, that might fit the, maybe rich people, they're not immutable, and they certainly don't have a history of discrimination. And then finally, the courts have said that a suspect class must have had a history of political powerlessness. This kind of makes sense because if a group had a lot of political power, then one would assume that the laws are designed to favor them. Those that are politically powerless are obviously more likely to be the victim of laws, and as a result, so they're more likely to be a suspect class. And so you can see race certainly fits into all 4 of these criteria. The question is, what other groups fit into the suspect classification? Well, the Supreme Court has over time decided which groups are protected by the 14th Amendment and which ones aren't. And one category, of course, that we've already talked about, but we'll expand on it a bit, is race. But the court has also expanded that to include ethnicity and color. And these are not exactly the same. Obviously, race and ethnicity may overlap, but certainly they're not identical. And color discrimination is also prohibited by the Constitution. Even individuals within the same race or within the same ethnicity occasionally discriminate against each other merely on the basis of their color, and the courts have said that that's unconstitutional. Religion is also a suspect classification, although this is not because of the 14th Amendment. It's more because of the First Amendment. Individuals are guaranteed the free exercise of their religion, and as a result, governmental actions that discriminate on the basis of religion are inherently suspect. But religious discrimination is prohibited by the First Amendment to the Constitution. The courts have also decided that national origin is a suspect class, so you cannot discriminate on individuals simply on account of where they were born, particularly if they are United States citizens. And really, that is it. So the list of suspect classes that the Supreme Court has come up with is relatively short. And what that means is most other groups are non-suspect classes, and many of the groups that we think of as victims of discrimination are in this group. So this would include age. The government is constitutionally permitted to make distinctions between individuals on the basis of their age. It also includes disability. This may surprise you, and we will certainly talk more about disability discrimination, but the Supreme Court has indicated that disabled individuals are not a suspect class. Socioeconomic status is also not a suspect classification. The government is free to treat people differently on the basis of how much their income is or how much wealth they have. That is permitted by the Constitution. And so these kinds of classifications, remember the significance is that if government does pass laws that discriminate on these bases and they are challenged in court, the government only has to meet the rational basis test. So, for example, many states require drivers age 70 and older to take driving tests more frequently than other individuals have to take driving tests. And as a result, the Supreme Court has ruled on that and said, well, that is a rational thing to do. Older individuals tend to decline in their physical capacity, and it's rational for the state to test them more frequently. And so it's very easy for the government to justify discrimination based on these various categories. Now, there are two major categories that we haven't talked about that deserve special consideration, and one of those is gender discrimination. Where does gender fall in the suspect and non-suspect class categorization? Well, gender is actually in a category almost entirely its own. The court has indicated that gender discrimination or gender is a semi-suspect class. What does that mean? Well, I won't get into the specific legal test, but the semi-suspect classification for gender basically stands for the proposition that virtually all differences between men and women are irrelevant under the law, but occasionally it is justified to treat people differently on the basis of their gender. So, for example, while it is unconstitutional for prisons to segregate on the basis of race, it is constitutional for prisons to segregate on the basis of gender. The same is also true for the military. So, gender discrimination, don't want to get into all the details, but it simply means that virtually all classifications based on gender are unconstitutional, but a few more of them are constitutional than racial classifications. And another example, registration for the draft. The Supreme Court said that it was constitutional to only require men and not women to register for the draft. And then finally, what about sexual orientation discrimination? Well, this one is one of the most interesting to talk about because it's certainly one of the most unclear. It's certainly tricky. I want to make clear that the Supreme Court has never, ever specifically said that being homosexual puts you as a suspect classification. Homosexuality is not a suspect class. They've never said that. However, as many of you know, or you certainly know, in 2013, the United States Supreme Court declared the Defense of Marriage Act unconstitutional, and in doing so, they said that the Defense of Marriage Act allowed the federal government to fail to realize gay marriages that were conducted in the states that made them legal at the time. And in striking this law down, the Supreme Court said the federal statute is invalid, for no legitimate purpose overcomes the purpose and effect to disparage and to injure. So this suggests that it has not met the strict scrutiny test, and in fact it suggests it hasn't even met the rational basis test. And so although the court hasn't declared this a suspect classification, the way that it treats it certainly seems to suggest that it is. And then this impression is reinforced by Obergefell v. Hodges, the 2015 case in which the Supreme Court declared laws against gay marriage were unconstitutional. Now, this was an interesting one because they really based their decision more on the due process clause. They tried to avoid the equal protection issue. They did not declare gays to be a suspect class. But nevertheless, again, just as in the other case, the majority suggested that anti-gay laws violate the rational basis test simply because they are based on animus, and therefore, even though sexual orientation has never been declared a suspect class, it really has all the equivalent legal protections of a suspect class. So we can say that it's a suspect class in name, in fact, if not in name. So that's where that stands.